The broadcast is now starting. All attendees are in listen-only mode.
Hello one and all, and thank you for your attendance. I'm Ken Parker. I'm delighted to have been asked to host this hub webinar for the AQR. Now, this webinar is a bit different from those you're more used to because we're looking at the serious side of data protection and what you can't do and must do within our daily lives. If we get it wrong, there's no excuse. The new legislation could result in a very heavy fine. But more than that, we're all very moral and law-abiding people, I know, so we wouldn't want to get it wrong, would we? With this in mind, I'm delighted to have Dr. Michelle Goddard sitting next to me. Michelle is the MRS Director of Policy and Standards, and believe me, with her legal background, there's nothing she doesn't know about data protection. Michelle is going to take us through this subject over the next 20 to 30 minutes, during which time I want you to think of the trickiest question that could catch her out. Then submit this, and Michelle has kindly offered to answer them in the next day or two. She's laughing and shaking her head at the moment, so I think she's got the message that a tricky question might be on its way. So without further ado, over to Dr. Michelle Goddard.
Many thanks, Ken, and thanks to all of you who've given up part of your lunch hour to listen to the scintillating topic of data protection. But having said that, it is a critical topic. I'm trying to change my slides, so just bear with me because it's not working. Well, I'll introduce the topic and I'll get the slide deck working in due course. What I'm going to aim to do this afternoon in the period is speak about the key differences between the Data Protection Directive and the GDPR, and provide you with some tips to help with implementation and planning for compliance. Now, why does GDPR matter? Why is it so important? Well, we've all seen all these very highly publicized examples of data breaches, which give pause for thought. They sweep up all different kinds of household brands and cross all sectors. Some of the most recent ones include the TalkTalk breach, that was reported in February 2016. And it cost £60 million, and TalkTalk lost up to 95,000 customers. That resulted in a breach which led to a fine by the ICO of £400,000. Now that seems a lot, but as you'll continue to hear later, that's small change compared to what the GDPR provides. But it doesn't just apply to large companies. We've had the recent Tesco Bank attack, which has led to losses of up to 2.5 million and losses of customers, and that could lead to potential large fines under the DPA or the GDPR. But data breaches also affect smaller organizations. So there was the case of 56 Dean Street, a simple data breach in that it merely involved an email being sent out in which recipients were copied instead of blind copied, and thus disclosing sensitive information about HIV status. Similarly, Alzheimer's Society has been investigated by the ICO in terms of how they deal with personal data. So these kinds of issues affect all kinds of organizations, and robust data protection is critical across the board.
Michelle, someone's just asked, what's GDPR mean?
GDPR, thank you, Ken. You get used to speaking in all these acronyms. So, General Data Protection Regulation. And the important phrase about that is regulation. It differs from the current directive in that it's a regulation which comes into effect automatically in every EU member state. So the GDPR, now we're familiar with the abbreviation, comes into effect on the 25th of May 2018 across the EU. I can hear the question about to drop, but we're not going to be in the EU, so why does it matter? It matters because Brexit is irrelevant in this instance. The government has confirmed that on the 25th of May we'll still be within the EU, and they've also confirmed specifically that we will be required to comply with the GDPR. So as of that date, it will be part of the English laws within the UK. However, even after that, we'll still need to have an adequate data protection regime to ensure that we can have cross-border transfers between data held in the UK and held in the EU. And the GDPR also has greater extraterritorial reach and seeks to stick to organizations that operate outside the EU once they're processing data from EU residents. So it matters. It matters now and it'll matter in the future. I think it's important to kind of give some background to why there was a need for a harmonized framework across the EU. The directive was implemented in a quite fragmented form in different member states. So in Germany, you'll have one Data Protection Act. In the UK, a different one, in Ireland, a different one. So if you want to do business across the EU, it's difficult to know what the obligations are. And that was a primary driver for the GDPR, making sure there'd be consistency across the EU states. Of course, the other great drivers were the fact that technology has developed quite a lot since the directive came into play. We've got expansions in internet and mobile telephony, and it's designed to make Europe fit for a digital age. If you think about how research has changed over that period of time and how things that we use now in terms of doing research using wearables, tracking biometric data have become techniques that are quite wide used, you'll kind of understand why the framework needed to change with that. So it aims to create a single set of rules. It aims very strongly to enhance and strengthen individual rights and to give individuals greater control of their personal data. And privacy is a fundamental right that must be respected. And of course, it aims to facilitate business by simplifying rules. The jury is out as to whether or not that's been achieved, and by the end of this talk, you may think otherwise. But I think importantly, the GDPR was one of the most heavily lobbied pieces of legislation on the EU books, and there were over 3,000 amendments to the initial draft. So what we now have is a final text that strikes a balance between privacy rights and legitimate commercial interests. None of the parties are probably happy, and that's probably a good thing, in that there's a balance that's been struck there. So, what are the key differences from the current Data Protection Directive? And I'll try and pull out, about four major differences. The first one is that it has much broader scope. So I've mentioned the fact that it has extraterritorial effect. So it impacts on the activities of researchers who work in the EU, as well as those who work further afield. It applies to those people who offer goods and services to the EU or who monitor the activities of EU residents. It's a very data subject, individual-centric piece of legislation. It also has much broader scope in terms of the type of data that's captured. So the category of personal data has now been expanded, and personal data is data that identifies or can identify an individual. So you've got the obvious things about, name and address, etc. But it also depends on the context. Importantly, it's now very clear that online identifiers such as cookies or digital fingerprints are clearly personal data. There's also new categories or additions to sensitive data, so biometric data, genetic data, and data about sexual orientation are special categories of data that need to be treated sensitively. So we've got wider scope on that respect. Individual rights have been strengthened considerably. So there are new rights that allow EU residents to be forgotten and to move their data around, to port their data to different providers. Existing rights are stronger, and you'll be required to provide a lot more information and greater transparency with that. There's a requirement to promote all these rights to individuals in a much shorter time to comply with that. In terms of if you want to get consent for processing data, that test is now much tighter. So you've got to have specific, informed, and freely given consent. So that will require a change for some persons in terms of how consent is collected. And there's also a much clearer requirement that means that if you're processing data as a controller or a data processor, you need to be able to provide evidence that you obtained consent, and that's going to require much better record keeping. So we've got stronger individual rights, and going along with that, we also have much greater accountability on businesses. Now, I hope that all of you who are listening and who control data have done your duty and registered with the ICO or notified the ICO about your activities, because that's a current requirement. You may be pleased to learn that you no longer need to do that, as onerous or not as it may be. That has now been swept away. But in its place is a requirement for much greater internal record keeping, which means that, what you would have done before in terms of sending the ICO a short paragraph of how you record data, what kind of data that you keep, that now needs to be replaced with what you keep internally. And I think that's probably a harder requirement because it's a lot more detail in terms of the categories of data are required, although there are distinctions made between smaller and larger businesses. There's also normally quite a lot of discussion in the research community about whether you're acting as a data processor, where you're just acting on instructions, or a controller, where you're the person who is determining the purposes for which the data is being used. And that has there's a big difference in terms of responsibilities under the current legislation. That's minimized a little bit more under the regulation because the regulation places responsibilities upon data processors directly. And therefore you have a much higher risk profile. You now have direct obligations and action can be taken directly against you. So whether you're acting as a controller or a processor, it's important that you understand the GDPR and take steps to protect yourself. There's also details about new terms that have to be included in all contracts for data processing purposes. And this is likely to lead to, I think, a lot more lengthier, protracted contracting with clients. You'll possibly see greater requests for information about your practices because there's a much greater duty on the controllers to make sure that the kind of supply chain is also treating data robustly and securely. Additionally, there's an obligation to report breaches, a mandatory obligation to report within 72 hours to data subjects, data controllers, and or the ICO, depending on the likelihood of risk, but not if it's unlikely to cause harm. So there's a greater, onus on you to report any breaches that may occur, whereas now it's somewhat voluntary. There'll be a need to appoint a data protection officer, and this isn't related to the size of the firm, but it relates to the kind of data that you hold. So if you are involved in large-scale processing of sensitive data, and I say that slowly and deliberately because no one knows what that means. Does it mean a lot, the number of records that you hold? Does it mean in relation to the kind of business that you do? That's not yet entirely clear, and we're seeking guidance on that. But I think the important thing to draw from that is that as researchers holding a lot of personal data and investigating sensitive areas, you may be required to have someone who's responsible for data protection in that way. And of course, as we kind of would have trailed in some of the introductory information, the important thing to recognize is that the sanctions regime has been turned on its head, and you can now be fined up to 20 million euros or up to 4% of turnover. And even though that's unlikely for smaller businesses, it's still important to recognize that it's a big sea change from the current fine, where the maximum is £500,000, to a fine that goes in excess of £15 million. So you would expect that even for smaller breaches by smaller organizations, the fines were likely to increase. And there's also, rights for individuals to take actions directly, to claim compensation, for consumer or privacy groups to take action on behalf of consumers. There are criminal sanctions. So there's a much broader range of powers that can be exercised. I think we're lucky in the UK and that we have a regulator that is quite pragmatic and listens to business and is, willing to kind of provide a lot of guidance. So even though I'm stressing the punitive nature of the regime, I think we can expect a fair amount of guidance as to how to operate ongoing in terms of how to avoid the major penalties. So that's a kind of very broad sweep as to what the key changes are. And I'll now speak a little bit about some of the actions that you can take to comply with the GDPR. GDPR requires a clear implementation and compliance plan. So the first thing that you need to do is to understand your data use. Understand the type of data that you collect, how it's used, and where it's stored. So think about what you do with your transcripts. Where do you store your participant contact details or completed questionnaires? Who has access to them? Are they on a USB drive? Are they on a shared drive? Are they on employees' individual computers? Think about where they're located and what you need to do to keep that secure. That's one step. Then you also need to take steps to implement the core obligations under the GDPR. And one of those is written contracts. So you'll need to review the contracts that you currently have. They are mandatory in all projects where you're processing personal data. So you'll need new contracts with agencies, with freelancers, with clients, or any other service suppliers. And the GDPR sets out core mandatory terms that must be included. For instance, if you're acting as a joint data controller with a client, you'll need to think about who is responsible for providing information to participants if they want to enforce their right. Is it yourself as the researcher, or is it the client? If there's a data breach, how are you going to operate together to make sure that the regulator gets the appropriate information? There are lots of questions you need to think through about how you operate and reduce that to writing. If you're a data processor, then the new contracts will include terms about audits, requirements in terms of being the controller, being able to approve any sub-processor you want to appoint. So say, for instance, you have some transcripts that you want to have translated, you'll need to get approval from the data controller for that. They might want to give that to you up front in terms of giving you wide discretion as to who to use, or they may wish to name a specific company. But these are some of the things that you might want to think about in terms of preparing for that. And of course, at the core is security, ensuring that you've got very robust measures that are put in place. So think about how you can use encryption or password protection depending on how sensitive the information is that you're dealing with. Tip 2, embedding privacy by design and default across the business. Now this is a principle that is new and very much, I suppose, stressed under the GDPR. It's a way that we try to operate currently, but it's been made very overt under the GDPR that you're expected to operate in a way that minimizes the amount of data collected to only what is necessary. So when you're planning a research project, think very clearly about what you need. Are you collecting the information because you're going to use it, or because that's what you always do? Doing what you always do isn't appropriate. You need to do what's required for the particular project. If you have databases that have participant information on them, make sure that they're accurate and that they're up to date. Once you have information on an individual, they can make a request for it, and ask to see it, and it's important that what you have is accurate. If you don't need it, then get rid of it. So also consider your data retention policies. Of course, if you're working with data, there are different techniques that you can use to de-identify it, or as the GDPR uses, pseudonymize it, so that you work with data sets that don't contain identifiable personal data by stripping out the personal data and having a code that allows you to put those data sets back together. Those are important techniques for maintaining, for fulfilling obligations under the GDPR. Importantly, when you're kind of thinking about how you want to comply and what you need to do, is to think about the risk level for all the projects that you're doing. The GDPR has provisions about privacy impact assessments, and these are important for riskier or large-scale activities. And they are what they say, I suppose, in that it's a technique that allows you to think about the research or the activity that you're undertaking and determine how risky it is and what steps should be taken to minimize that risk. You work with people within your organization, with other partner organizations, with people affected, with individuals, to see how you can identify it and reduce any privacy risks. And that's another technique that's useful in terms of understanding your data use and how you can minimize. The next tip, top tip 3, goes back to what I spoke about in terms of research and research being a social contract with participants. And I think this is the basis on which we operate. Ken mentioned us seeing ourselves as ethical, and I think that is something that distinguishes us from other persons in this space. And this is just a natural progression of that. So being transparent and respecting the rights that are given legally. And you can do this by ensuring that participant rights are properly protected. So think about how you get consent and how you document it, because the burden is on you to show that you have consent. Look at your privacy policies and notices. These are really important. Can you make it clearer? Is it in plain English? The GDPR requires a lot of information to be provided, but it also requires that it be done in a very simple manner, in plain language. This may be the opportunity to get the marketers involved, get those copywriters involved, people who can translate the complex topics into easy, simple language. It's a job for lawyers initially, but then it needs to be, I think, moderated so that people can understand what it is that you're saying to them about how you use their data. Make sure that your procedures and your systems will allow individuals to exercise their new rights. So they've got the right to access to understand what information you hold about them, subject access requests. These now have to be done within 30 days rather than 40 days. And whereas currently you can charge a fee of up to £10, they will be free. So you need to build that into your systems to make sure that you can, fully comply with that. There are new rights to be forgotten, to object to processing, or to port data. So you might want to think about how you can build those into your systems. Do your employees know what to do if they receive a request for access or to be forgotten? You need to make sure that employee training is also built into this and that everyone is clear as to what steps are to be taken or who to go to. And I suppose critically, will you need a new budget for this? I'm speaking glibly about IT systems, but they cost money. So you might want to think about that in terms of what you currently have and whether additional monies are needed in terms of being able to comply with that. So 2 more tips to go. The next tip, it's important to be accountable and to demonstrate responsibility. So how do you do that? I spoke earlier about the need for internal records. You need to make sure that you've got an appropriate system that allows you to update internal records for all types of written record keeping. And this will be mandatory for your higher risk activities, those where you're processing sensitive data, for example. Think about who you'd like to appoint or who would be suitable to be appointed as a data protection officer. Nominate someone who's responsible. This is a very important role. The person that's appointed as data protection officer has protection from dismissal. So it may be that you want to also think about outsourcing this role to a legal firm or a consultancy. But I think if you do process a large amount of personal data, you need to think about whether or not you need to do that. Make sure that you've got procedures set up for breach identification, notification, that staff know what to do and who to report to. Make sure that they understand when they need to report back to a client, when you'll need to report a breach to the ICO, and that everyone is following the same script. And it's important to also consider ethical obligations under industry codes. The legal regime under the GDPR is a lot higher and a lot tighter, but the codes of conduct often go a lot further than that. So you want to make sure that you're demonstrating your responsibility by following all the rules that are in, either the MRS code of conduct or the SMR code, whichever code it is that you follow with respect to the industry. This will become increasingly important because the GDPR provides adherence to a code of conduct as a way for demonstrating compliance. And so codes of conduct will be revised and reviewed in order to make sure they comply with that. So that's a lot of information and a very broad sweep in terms of what the changes are. But I think the one message that I do want to get over is that you understand that compliance isn't just a tick box affair. It needs a complete strategic and cultural shift in terms of how you treat data protection and what you think, how you deal with privacy. So review your existing use. Draw up a compliance plan that deals with your IT systems, your staffing, your policies, and then commit to this. Consider it when you're creating new products or new research projects. Ensure you can innovate, but using the right privacy perspectives. You need to use impact assessments for riskier projects, or data minimization techniques to limit the amount of data collected. Retain and store data only as long as you need it, and limit accessibility by staff. That's part of committed to data protection by design and default. And finally, embed the shift in a pro-privacy culture within the organization, in your staff and in your processes, through training, through a commitment to robust protection of data. And of course, watch this space as MRS will work with AQR to provide advice to membership on what the GDPR will mean for what you do as a researcher.
Wow. Well, thanks very much, Michelle. I don't know about you, but I feel battered. Here we go. I mean, there's some things that you said there I thought were very pertinent, such as keep the stuff only as long as you need it, because how long do we need stuff, which comes to my mind all the time.
And that's a question that we often get, that I do get asked quite often. So there is no, kind of, I suppose, golden rule. But what we will generally say is that, for instance, primary records which contain personal data, keep those for about a year. Secondary records, keep those for about 2 years. I think what's most important is that you identify how long you need the data for. So think about, how long does the client require you to keep it? How long are you going to use it? And then set a period of time and stick to it. And make sure the client knows how long you're going to keep the data so that that's reflected, so there are no surprises. So it's about thinking about how long you need it for, communicating that to the client, and then sticking to that.
Excellent. And another thing that strikes me is we talk about personal details. I'm not quite sure what a personal detail is. I know that a name, an address, gender, sexuality, things like that are personal details. But so much of the stuff we do is on videotapes and audio tapes and gives us an indication of people's lives and things like that. Is that personal data?
Well, if you're recording them, then yes. So the videos and the audios, then you are recording and taking personal data, and you need to follow Data Protection Act. But I think more broadly, you're quite right in that you may be collecting details about context as opposed to precise information about name or age, etc. And it all depends on whether or not you can identify someone from the information that's been given. If it's either directly or indirectly identifiable, then it's personal data and you need to take steps to protect it. So what I would suggest that you do is treat most data as though it's personal, so that you're making sure you're meeting those obligations, and that's probably a better way to ensure compliance.
Excellent. Well, thank you very much. And there have been questions coming in as we've been talking. I think the best thing is if Michelle could write back to these guys individually. One of the questions that came in is, are slides going to be available after this? And indeed, yes, they are. And so is a recording going to be available. So in a couple of weeks' time, it will be up on the AQR website. So if you want to watch it again, or if a colleague wants to watch it, then keep an eye on the AQR website because it will be coming there. In the meantime, Michelle's got another point she wants to make.
Now, I was just going to say that in addition to the slides, what we'll also make available is we've developed a compliance timetable, which essentially sets out key actions that you should take between now and May 2018, divided into phases. So I think it provides kind of bite-sized chunks of action points, and we'll make that available at the same time as well.
That's fantastic, because the more stuff we get from you, I think the better. I think that's been endorsed by some of the questions and points that have been put up here at the moment. So I'd just like to thank Michelle for that, because that's a tough gig, that one. And thank you very much for devoting your time for the AQR today. I think we really appreciate it. And before you all go, there's a little bit of AQR parish news that I need to relate. The Young Unfocused Group's AQR, see how they do that? It's really clever, isn't it? Yeah, the UG's AQR on the 7th of December, and you put in a team for this quiz. It's a pub quiz. All teams are going to be welcome. You need 0 to 7 years experience. So you old timers, sorry, there's no place for you. But it's for the younger researchers, and full details are on the AQR website. And if your company has one, don't forget to renew your directory entry for 2017. And if you haven't got one, you should have one. So please don't be shy on that one. Get your directory entry in. And then to save the dates. The first is on the 9th of February, is the renowned and fantastic Not the Christmas Party. So please keep your eyes out for that one. It's on Thursday, the 9th of February. And on the 8th of June, there's the AQR conference. It's called, I'm not sure what it's called really. It's either called Revolution or Evolution, because the first R is in brackets. Very clever. So it could be Revolution, it could be Evolution. Depends on which side of the fence you're sitting. So I doubt we'll have another webinar in the next few weeks. So it just remains for me to say Merry Christmas to you all. From me, Michelle, ta-ra. Thanks a lot.